Good morning.
Yeah, don't forget to record.
Good morning and welcome to Chapter 1, Part 1 with Jay Richards. I'm Meg Foley. I'm the Professional Development Coordinator for the Board of Building Standards. I'm also the one who sends you all the annoying emails, and so you probably are pretty familiar with me. Jay Richards is one of our staff architects, and he will be walking you through the ins and outs of the first portions of Chapter 1 today. Jay does a great presentation. I'm sure you'll learn a lot. I always do every time I watch this one. And take it away, Jay. Enjoy the show.
Thanks, Megan. Appreciate that. Welcome. Good morning, everybody. Hopefully, you've all found yourself a safe, warm spot to watch Chapter 1, Part 1. Hopefully, I'll be able to bring you some insight that will help you understand the Ohio Building Code and its enforcement. Just on a personal note, I have been in practice of architecture for north of 25 years and then been with the board for almost 5 now. I'm in that 4.5 range. And one of the first things that I learned at the board and what has helped me tremendously, and one of those things that I wish that I knew better when I was a practicing architect, is that Chapter 1 is your friend, it's the owner's friend, it's the builder's friend. Everybody should know and understand Chapter 1, and it will help answer a lot of questions and problems. Always recommend that when you have a code-related question that you might be a little stumped on, one of the best pieces of advice I've received and I give is think about Chapter 1. Go back to Chapter 1 and see how the process is supposed to work. And a lot of times some answers will become very clear. So without further ado, I have a lot of slides to get through. It's been a challenge in the past, and my hope is that we can get through them today and maybe a little early. So with that, let's see where we're going to go. We are Chapter 1, Part 1. So this is all about the process. I have created this little diagram here, and it's going to recognize the fact that this is an interlinked process amongst a lot of different enforcement agencies. The Ohio Building Code is one of the documents used for enforcement, and it is enforced through the building departments. As with any building project, the goal of the owner is to build themselves a building that meets their needs, that they can occupy. And that is the goal, and that should be everybody's goal. And the board's goal is to do it safe, make it safe, sanitary, energy conservation minded, and accessible when required. And we want to do that in a way that is clear and transparent and helps the owner be happy and pleased, and it shouldn't be a fight. So the Ohio Building Code is going to be all about the building process, and we'll be looking at that more closely today. We will also look a little bit about how this process is interlinked with some of the other enforcement authorities, and we'll go through that at a later point in the presentation. So the Board of Building Standards, what is our responsibility in all this? Well, we are to formulate and adopt building codes that provide safety and sanitation, energy conservation, accessibility. And we have 2 families of codes that we write building codes for. We have the Residential Code of Ohio, which are the uniform requirements for residential buildings. And we have the Ohio Building Codes, which includes the building code, the plumbing code, the mechanical code, and these are for non-residential buildings, and these are the minimum requirements. So that is what the board is charged with, as well as we work on the process for authority to enforce the certifications of building departments and personnel, and we write Chapter 1. It's the process. As you may or may not know, the building code is based on the International Code Council model codes, and for us, the 2017 Ohio Building Code is based on the 2015 IBC, International Building Code, less Chapter 1. So Chapter 1 is all Ohio language. So when you go look at any of the commentaries on the international website, the commentaries on Chapter 1 in the IBC are relative to the IBC. They are not pertinent to Chapter 1 of the OBC. And we have written our own commentary, and I will be showing you that in a little bit. So to get started with, we're going to do a little more introduction, and we're going to talk about some keywords that you should know. So Chapter 1 is all about the administration of the building codes and the building process, the regulation in the building process. It serves, we're going to talk about what it serves to and how does this help. It's going to organize the process, it's going to interrelate with other regulations, and it's going to establish duties and responsibilities for everyone and provide the procedures. So remember, if you're stumped about something, come back to Chapter 1 and see what Chapter 1 says about the process. So how does this help? It makes the code easier to navigate, understanding the enforcement procedures. It does create a common arena for all participants. So it should be helpful to the owner, it should be helpful to the builder, it should be helpful to the code official, the designers, everybody who uses it. And as I mentioned, because Chapter 1 is all Ohio language, in the 2017 Ohio Building Code, we have generated a commentary. This is the title page for the commentary. It should be in the packet of information that everybody has access to relative to Chapter 1, Part 1. And I strongly urge you to download that, keep a copy. You might want to print a copy. Maybe you want to include one in the front of your code book. Feel free to have it with you today. You can highlight some things, or after today's presentation, maybe go back and highlight some things in the commentary to help remind you some of the things that we're talking about today. So Chapter 1 is organized in a very logical manner. There are 15 sections in Chapter 1. These are the titles of those sections. I have carefully color-coded them. The first two sections are basically what is the code, or what is and isn't covered in the code. The next two chapters are who can do what, so duties and responsibilities. You'll notice that 103 certifications has moved to Ohio Administrative Code Rule 4101:7. So if you're looking for the certification rules, basically building departments and personnel, you need to go over there, where the next two chapters are all about what needs to be submitted. And these are kind of guidance and direction to the owners and designers of buildings and what they need to provide to the building departments to get their approvals, which that's the next group of things, is how does the building department and the personnel assure compliance with the building code? That's going to be 107 through 110. That process has to find, the application is the beginning, the certificate of occupancy completion is the end. So this is the tool used to communicate to the owner that this particular approval has found an end and it is okay to occupy. And then the remaining sections are unique processes to Ohio. We have split this whole thing into Chapter 1 into two parts. I'm doing Part 1. Rob Johnson is going to do Part 2. And in Part 1, I'm going to be covering these sections, 101, 102. So what is or isn't covered. We're going to talk about approvals, and part of the compliance process. Rob's going to pick up the last part, and then I will do certificate of occupancy, and Rob will do those other sections. Pretty much my stuff is going to be about a project that goes smoothly from beginning to end, that the building owner and the designer know what the code requirements are. They design a code compliant building, they do all the right things, and this is as smooth as it could run, is basically addressed in these. Some of the sections that Rob is going to get into and present in part 2 are what happens when that process goes south or takes a misstep, or an owner has not provided a code compliant proposed project. So definitions are always important, and it's good to remember that when you are looking at the building code, there are a whole slew of defined terms, and all the defined terms are going to be found in Chapter 2, and they will clarify an understanding. Specific meanings will be in Chapter 2. We've also captured some of the important ones in this commentary. And then if a term is used in the building code and it's not a defined term in Chapter 2, then basically general usage applies, and you can find common definitions in a published dictionary somewhere. There are 15 definitions selected from Chapter 2. They're brought forward into the commentary, and they're more clearly defined and outlined. We're going to discuss 5 of those 15. All of the 15 are important, and as we go through the 5, you'll see what they're dealing with. The remainder of the 15, the 10 or so that are left, are dealing with some exempt buildings and systems, industrialized units, and some other terms. But the 5 that we're going to talk about are pretty broadly applicable to all building types. So the first term we're going to talk about is a building official. I have brought forward the definition from Chapter 2. It also appears in the commentary. In case you wanted to know, I may refer to the commentary every once in a while. Sometimes, like definitions here are going to start on page 6, or this building official definition is on page 6 of the commentary. And essentially what a building official is the authority charged with the administration and enforcement of the code. Okay, so that is, in a nutshell, what the building official is. The building official, there actually can be a variety of positions that can serve as a building official, and they're outlined in this definition. The first one is the superintendent of the Division of Industrial Compliance. The next one is a designated authority approved by the board in a municipal corporation, township, or county having a building department. Now, this category here is probably what most of you are sitting in this class today. You are a designated authority that is approved by the board. You have a certificate, or you're working on getting your certification to be a building official. The last one is the health commissioner or his authorized representative in health districts. So as you may or may not know, in your jurisdiction, the local board of health may have the authority to enforce the plumbing code. And to enforce the plumbing code, you need to have a building official status. So they can also be a building official to enforce the plumbing code. So know that, those 3. So in summary, the building official is the authority having jurisdiction, and they administer and enforce the code. That's their primary duty. The 3 types of building officials that can exist are going to be a superintendent of industrial compliance, a certified individual, or the health commissioner. And what can they enforce? They can enforce the rules of the board. And that's what we're going to be addressing today. In case you're wondering where we have the 3 different types of building officials, know that with the commercial code, the local jurisdiction is allowed to establish a certified building department. And if the local jurisdiction does establish a certified building department, one of the things they have to have is a building official to head up that certified building department. So that would be primary. And then in the absence of a certified building department in the local jurisdiction for non-residential buildings, basically buildings regulated by the OBC, the Superintendent of Industrial Compliance for the state of Ohio is by default the building official for that jurisdiction. So no matter where in Ohio someone builds a non-residential building or a commercial building, there will be enforcement either at the local level through a certified building department or at the state level through the Bureau of Code Compliance in the Division of Industrial Compliance. And then plumbing comes along. Some local jurisdictions enforce plumbing. If the local jurisdiction is not certified to enforce plumbing, then it falls to the health district, and it may fall to the plumbing division in the Division of Industrial Compliance if the local jurisdiction doesn't enforce health. The next definition we're going to talk about is building service equipment. And this is the definition that appears. This is basically equipment that is integrated into the building. And its purpose is to provide heating, air conditioning, ventilation, fire protection, lighting, electricity, sanitation, water, heating, cooking, medical gas, medical vacuum, and clothes drying. So these are all going to be things that support the operation of a code compliant building. And to help define this building service equipment begins from the stored source of power and extends through the point of use. And we wanted to be really clear because of other definitions that it does not include process equipment. So the building code is not going to regulate the utility on the utilities side of the source, and that will be either the service point, commonly used in electrical systems, or the point of delivery, which is used in some of the fuel gas systems. And then it extends through the point of use. So wherever you consume that, and then the byproducts go off into the atmosphere, we're not controlling that end. The process equipment, we'll get into that in a little bit. But basically, this is something that's placed in the building and it doesn't contribute to the code compliant building. It may have an effect on the compliance, but it doesn't contribute to it. So important things in summary, it is integrated parts of the building. It's dealing with safety and sanitary operation of the building. Talked about where it starts from. And it specifically excludes process equipment. And then we have, there are some related definitions in terms of building service piping and process equipment and piping in the list of definitions. We're not going to, I think we touch on those a little bit later. So, fire prevention. Here is the definition as it appears, and fire prevention is about the safe conduct and operation of hazardous processes, the storage of combustibles, the conducting of fire drills, and the maintenance of fire protection, detection, and extinguishing service equipment, and good housekeeping. One of the things that you'll notice about all the things in here is these are about actions that are taken after a building is occupied, typically. It is about particularly here when we're dealing with the storage of combustibles and flammables, this is about the inclusion of a fuel load. So that could change over time as building owners move things in and out. Maintenance is an owner's responsibility, and it is not the building department's responsibility to follow, at least under the requirements of the Ohio Building Code, unless the maintenance is not performed to the point where the building has developed a serious hazard. Then you'd be addressing a serious hazard, and I'll go into that a little bit more later. So one of the things you'll notice is we talk about fire prevention. Then we also have fire protection. And is there a difference? And I can definitely say without a doubt there is a difference. The reason I've highlighted these, one in red and the other in blue, is to help emphasize that difference. Fire prevention are preventative measures. These are things that the owner is responsible to do, and we talked about them in the definition, conduct and operation, storage of combustibles, performance of drills, maintenance, and good housekeeping. Fire protection, now these are going to be the integrated systems in the building that are incorporated into the building as you're building it. Now, going back to building service, remember in that list, fire sprinkler systems were included. Under electrical systems, you can have fire alarms and those kinds of things. Those are integrated systems into the building. They are there to, they are needed to be approved devices. They will detect a fire, activate an alarm, extinguish or control a fire, and control or manage smoke. So these are the protections. The fire protections are regulated under the OBC. Fire preventions are actually regulated through the Ohio Fire Code by fire officials, fire prevention inspection personnel, actually. And it's more long-term observation. It's as the building is occupied and over time, owners are going to have requirements to have annual inspections by the fire prevention officer to assure that the operation of the building and the service equipment related to fire protection, that they maintain the same level of safety as originally approved. So things like the storage of combustibles and hazardous materials. If an owner changes that stuff and the building's not approved for the new materials, the fire official, through the long-term observation, is supposed to catch that, may write the building owner up and for the owner to correct it, they either have to get rid of that combustible that they're storing, or they may have to submit to the building department to get an approval to do that and make whatever changes are necessary to the building. It is addressed in Ohio law. I mentioned before that it's the use and enforcement of the Ohio Fire Code. That's fire prevention, and it is by local fire prevention inspectors. Fire protection is done through the building code approval process through construction. Minor repair. This is the definition as it appears. It's fairly lengthy, but it basically gets broken down into two parts. It's going to be broken down into what minor repair is and what minor repair is not. So what minor repair is fairly simple and straightforward. It is the reconstruction or renewal of any part of an existing building for the purposes of its maintenance. What minor repair is not, it does not include any of these things that are listed here. It does not include the addition to, alteration, replacement, or relocation of any of these building service equipment pieces. So this is the structural part of the building. This is the building service part of the building. And it does not, if the owner is proposing any of this type of work, it is not minor repair. It may still be repair, it's just not minor. And I'll talk about why that's important here in a minute. So it is work to construct or renew for the purposes of maintenance, and it is limited. It's minor in impact on access, safety, and health. The repair must comply with the existing or previous approvals, because that's essentially what they have been approved for this, and they can do it. They are responsible to maintain in accordance with their existing approval. And why it's important is that in section 102.10.2, minor repair is exempt from approval. They still have to comply with the existing approvals, but is exempt from approval through the local building department. What it is not, again, I've just listed out the stuff that was in that definition. I may use some slightly different terms to help understand. For example, building service piping, electrical wiring, building service equipment. If they start doing any of these things, in the removal of walls, it's typically going to deal with the load-bearing walls and load-bearing support conditions. Next important definition to really get your arms around as a building official is a serious hazard. And first and foremost, it is a hazard. It's not necessarily something that's non-compliant or something that's old or something that's unmaintained. It does have to rise to the level of a hazard, and specifically it rises to a hazard of considerable consequence to safety or health. It goes even further than that, that this hazard, it's been established through experience to be of certain or probable consequence. Very important. It's considerable, it's certain or probable. Or let's say you don't have any experience with the hazard, it can be determined or is obviously such a hazard that you may not have ever seen it before, but if you can determine or it looks obvious that it will be certain or probable to have considerable consequence to safety or health, it rises to the level of a serious hazard. So we'll just summarize it a little bit more. It is considerable. It is established through experience, can be determined or is obvious, and it is established, determined, or obvious. All that is determined by the building official and only the building official. If an inspector out in the field sees something they think is a serious hazard, they should be picking up their phone, contacting the building official, describing it to them to get some idea from the building official whether the building official believes that it is a serious hazard and then takes appropriate actions. Action is required by the building official and must be taken if it's determined to be a serious hazard. Remember, considerable consequence that is certain or probable to the safety or health of the occupants in the building. It is not founded in conjecture or preference. It is not based on possible consequences. If you think that something might happen someday, that is probably in the possible. if you think that not having a cover plate on an electrical outlet is a serious hazard, that may be a preference. Depending on some of the other conditions of the building, it may not rise to the level of a serious hazard. I'm sure we've all seen electrical boxes that don't have cover plates on them, and they don't all start a fire, or occupants don't get electrocuted just because that plate isn't on there. So those are the kinds of things that you need to run through when you're thinking about whether it's a serious hazard or not. This is something that it is a pretty lofty responsibility on the building official, and it ties into a lot of the processes in Chapter 1 for when building departments take action regarding existing buildings outside of when an owner makes application for an approval. So moving on, we're kind of done with that intro and definitions. I failed to mention at the beginning that if people have questions along the way, I think Meg may have indicated in some notes at the beginning that you can use the chat feature and send a note in to record a question. And we'll try and answer those questions either at the end, maybe possibly as we go if one comes up. And then what we did in the last one is if we don't get to answer questions, we will at the end of this, or when I'm finished, I will get a copy of all those questions. I will create answers to them, and we will send those out. So just know what to do with your questions. I'm sure you likely have some. So moving on, Section 101 are kind of all the sort of general things. We're going to talk, talking about the titles and the model codes, kind of ties that together. We're going to talk a little bit about the purpose of the code. As I mentioned at the beginning, this is the Ohio Building Code. It deals with non-residential buildings. And remember that even though it says non-residential, there may be residential occupancies. Remember, Group R is out there. So hotels, motels, inns, Group R1s, apartment complexes, dormitories, multiple family buildings with shared exits, Group R2s, multiple family buildings with independent exits from each dwelling unit, Group R3s, and then Group R4s, which are care facilities for 6 to 16. So acts kind of like a group home where that's being used as a care facility. They are considered non-residential buildings regulated by the Ohio Building Code, but they are residential occupancies. Remember, our code is based on the International Building Code, or the IBC. It's developed by the ICC, and this particular one is the first printing of the IBC, which is important because as time goes on, the ICC may modify or amend the IBC through their 3-year cycle. We're based on the first printing, and it's for chapters 2 through 35. Notice that chapter 1 is missing. Ohio writes their own chapter 1, and that's what we're going through here. So then the purpose of the building code is covered in sections 101.2 through 0.4. It's going to address the scope, the intent, and referenced rules in sort of how we want, or how the board wants the building code to be applied, looked at, used, and we'll go into more conversation there. Also know that we have that second family of codes. It's the Residential Code of Ohio that addresses 1, 2, and 3 family dwellings. It too is developed in a similar way. It too has a Chapter 1 that is Ohio language. There is a separate commentary for the Residential Code of Ohio for Chapter 1. There are some differences there. Most of it is the same, but just know that there is a difference when you're dealing with the residential code. Residential code is going to deal with residential buildings. They are defined. They are 1, 2, and 3 family dwellings, but they do not include manufactured housing, industrialized units, or mobile homes by definition. So one of the things you'll hear from Rob later is that the industrialized units are actually regulated through the OBC and Section 113, and there's a special approval process there. So the scope 1012, what does, in broadest sense, what does the Ohio Building Code cover? And this is the charging paragraph as written, and notice down here at the bottom there are exceptions to the scope. Kind of breaking this down into some lists, we're going to talk about what types of buildings are within the scope. We're going to talk a little bit about dwellings, accessory structures, a little bit about land on which the building is located. So breaking it down, it applies to the construction, alteration, movement, enlargement, replacement, repair, equipment use, occupancy, location, maintenance, removal, and demolition of every building or structure or any appurtenance connected or attached to such buildings or structures. So there's not a whole lot that's not in this list when it comes to addressing a building and the actions or activities, construction related activities that an owner can perform. Cleaning is not there. And one final another note in here is that this code does apply to detached 1, 2, and 3 family dwellings only to the extent indicated in Section 310 of this code. This is primarily just a reminder that there may be some 1, 2, or 3 family dwellings out there that look like 1, 2, or 3 family dwellings regulated under the residential code, but because they have a business occupancy or commercial occupancy or one of the non-residential occupancies in them, it will be picked up in Chapter 3 under classifications, and more specifically Section 310 of this code. It allows some back and forth there. And this is basically bringing forward law in Section 379104 that no plans or specifications shall be approved or inspection approval given unless the building represented by the plans and specifications will comply with Chapters 3781 and 3791 of the Revised Code and any rules adopted by the board. So the Ohio 3781, 3791 gives the board the authority to adopt the rules, and the Ohio Building Code is one set of those rules adopted by the board. So is the Ohio Plumbing Code, so is the Ohio Mechanical Code, so is the Residential Code of Ohio. So it's the authority to enforce. Types of buildings that are within the scope. We kind of went through that already. Any of these construction activities, if you change the occupancy of a building, if you make it bigger, you change its location. If you're the maintenance, well, the building code doesn't require that you enforce maintenance. some of the maintenance activities that an owner is doing may require them to make application for approval to the building department. So that's why this is in the list. Replacements, removals, roof replacement is probably one of the biggest ones. It's a system that wears out. It needs to get replaced. That could be looked at as maintaining it in accordance with its original approval, but it does need approval by the building department if they are replacing their roof. If it's just a minor repair to their roof, they don't need approval, but if they're doing anything but minor repair, they need approval. Demolition, things connected or attached to the building equipment systems and that kind of stuff. Dwellings and accessory structures, you need to check 310 to see if they are regulated under this code or possibly over in as a 1, 2, or 3 family dwelling. So land incidental thereto. This appears in the revised code 378110 that there is or are some provisions in the building code that deal with the land incidental to the building that are regulated. The typical one is dealing with the slope of grade adjacent to a building and how you deal with surface water to help protect the foundation. That would be land incidental thereto. This does not mean that the building code regulates the grading of the whole site. It does not mean that the building code regulates setbacks, easements, other zoning provisions that might be out there in terms of development of the property. This is really only land incidental thereto, meaning the building, and they would be spelled out in the requirements of the code. Types of work that's outside the scope of the code. Remember, there's the exceptions down at the bottom of 101.2. There are 23 specific items listed under those exceptions. They are typically going to be structures regulated by other entities like the federal government or manufactured housing program or the Residential Code of Ohio. For other specific purposes like power generation or gas and oil processing. There are some specific things that are identified as not a building or part thereof. Best example I can think of there is a retaining wall out in the landscape, not associated with a building to protect its foundation. That would be not regulated. Land use, already talked about that a little bit in the previous slide. The building code doesn't deal with deciding insurance claims and the contracts therein about what's paid for, what's not paid for. We don't regulate property sales or ownership. We do not regulate any kind of contracts, contractors, who does the work, the level of craftsmanship that's required by the owner. Our focus is on a minimum level of safety, sanitation, energy conservation, and accessibility. Owners are allowed to exceed the requirements of the code. They don't have to just do the minimum. They can do more than the minimum. If they do go more than the minimum, they must comply with the provisions of the code if they do exist and they are providing more than the minimum. Moving on to the intent. This is basically the purpose of the code, and it is, again, the uniform minimum requirements, and it relates to conservation of energy, safety, and sanitation of the buildings. And I toss in there accessibility. We do have Chapter 11, which deals with accessibility. remembering that is compliance with a standard, and that the Americans with Disabilities Act, or ADA, is federal law and is enforced at the federal level and is a civil action. The owner has to respond to that independently of the building code. Typically, it has been that if they comply with Chapter 11 in the Ohio Building Code, they would also then have met the Americans with Disabilities Act. All that stuff is continually moving, but I believe it is still true today. Now, and this is all with consideration for performance, extent of use, and standardization of the building code. The performance is, in the building code, in the Ohio Building Code, we're going to set performance objectives. That it is a bar. It allows a great deal of flexibility on the side of the owner and their designer to meet those performance objectives without being super prescriptive, like over in the residential code. Extent of use, the goal is to permit to the fullest extent feasible what the owner wants to do in terms of use of materials, methods of construction, and whatever improvements they want to do without affecting the minimum requirements of health, safety, and security of the occupants. So you really want to be helpful, want to help them get it done. We're going to limit our review or use of the code to those items of health, safety, and security of the occupants. And we want to encourage the standardization as much as practicable. This helps everybody understand what is a safe and sanitary condition. And the last little bit is that the rules of the board shall be liberally construed in order to promote its purpose. Remember, these things up here are its purpose. We want to be helpful. We want to be able to liberally construe the provisions. That doesn't mean make them up, change them, use them differently, but look at what the language is, and is it possible that what they're proposing is compliant for a healthy and safe building. Because when the building official finds that the proposed design is a reasonable interpretation of the provisions of the code, it shall be approved. So if you look at something and you think that it is a reasonable interpretation, looking at it liberally, that it meets the health and safety, that you have to approve it. You may have an opinion about it, but you still would have to approve it. Section 101.4 talks about reference standards. This is where we start bringing in some other rules of the board, or I'm sorry, reference codes. We start bringing in some other rules of the board, and they will be considered part of the requirements to the prescribed extent. The codes that are referenced in the OBC, there's going to so we have the other BBS rules, which are the mechanical code, the plumbing code, the boiler and pressure vessel code, and the elevator code. And these are where they are located in the Ohio Administrative Code. And then the Ohio Fire Code is referenced through the OBC. This is, and it's the Fire Prevention Code, and this is where it's located in Administrative Code. Remember, it's to the extent. So from within the Ohio Building Code, you're going to have references to the Fire Code, and it's going to tell you the extent to which the Fire Code can be enforced from the building official's approval. Also, one of the things that we've included in the commentary relative to this is and this is the beginning of it, it is a laundry list of issues and questions relative to elevators, new passenger elevators, freight elevators, and Lulu elevators in non-residential buildings. talking about some of the common violations that they see. This is provided by Chip, the director, or the elevator inspections for the state, and he has made some presentations to various groups and is very happy to talk with any building officials that have questions about elevators and what they're looking at. Chip's group has certain responsibilities to deal with the elevator itself and its operation, because they have to inspect and license them. But there are things that the building department needs to look at relative to that elevator shaft and the structure in which the elevator is in and the systems that support it. And he likes, if there's any question, you're more than welcome to contact him regarding elevators and inspections. Okay, moving on. Section 102 is applicability and jurisdictional authority. I'm bringing back my little image here of the interlinked process, and we're going to be talking about the building official and their role in the building departments towards the building approval process. We're going to talk a little bit about fire officials and the fire prevention process. We're going to talk a little bit about local authority jurisdictions. We're going to talk about perhaps other agencies that may be involved by virtue of the operation that the owner wants to conduct is a licensed operation, like childcare or an establishment that serves alcohol or something of the like. So they have some licensing requirements. We're also, fire official may have some responsibilities after the building is occupied. The licensing group may have some responsibility after the building is occupied. These are typically the annual kinds of things, the renewal kinds of things. And then the building official, if there's a triggering event like a serious hazard, then the building official gets back involved in the process, and in all of these cases may send the process back through to get approvals to correct some of these things. So 102.1, one of the things we start off with here is in a general statement that different sections of the code can specify different materials, methods of construction, or other requirements, and this section is going to tell you that the most restrictive shall govern. So if you run into something where it appears that there are different requirements being specified for the same thing, the most restrictive shall govern. The other thing it does is that if there is a conflict between a general requirement and a specific requirement, the specific requirement shall be applicable. So it's similar, but it is a little bit different, providing a couple of examples here. Somewhere where the most restrictive will govern, OBC Table 506 specifies that a H3 occupancy allowable area of 5,000 feet to unlimited square footage, depending on the construction type. But what you'll also note is that when you start getting into hazardous occupancies, it's going to send you to section 415, and at 415.10.5.1, it talks about that H3 consumer fireworks facilities can't exceed 5,000 square feet. So you notice there is a difference, 5,000 to unlimited square footage, depending on the construction type. If it is a specific H3 consumer fireworks facility, it can't exceed 5,000 square feet. Therefore, that particular type of building used for that purpose is limited to 5,000 square feet for all construction types. Another example of most restrictive, table 307.1. Again, we're dealing with hazardous materials here. It permits up to 150 pounds of liquefied flammable gas per control area. Before the building is considered a Group H occupancy. So the occupancy could stay at whatever the main occupancy of the building is, because the amount of hazardous material is below 150 pounds. Remember that the code will also send you to section 414 at 307.1.2, sends you to 414 and the Ohio Fire Code anytime you have hazardous materials, whether it's above or below this number, hazardous materials. And you'll see that 414.2.2 reduces the quantity per control area and the number of control areas based on the story above or below grade plane of the hazard. So if this 150 pounds is a story above or 2 stories above grade plane, that number is going to get reduced, as well as the number of control areas that can exist on that floor. As a result, if they exceed that modified number, that reduced number, 414.2.2 may drive the occupancy classification of the building in lieu of 307.1, because they would have exceeded the allowable quantity of hazardous material. Therefore, it makes it a Group H occupancy, and then they would have to comply with section 415 as well. Now an example of a specific requirement. Section 304 classifies an ambulatory care facility as a Group B occupancy. 903.2 does not require, in general, automatic fire sprinkler systems in Group Bs. 903.2.2 requires automatic fire sprinkler systems throughout the entire floor containing an ambulatory care facility. And then 903.2.2 also requires that automatic fire sprinkler system throughout the entire floor and all intervening floors where the care facility is not on the level of exit discharge. So as a result of 903.2.2, this Group B occupancy with an ambulatory care facility will be required to have an automatic sprinkler system. So it is specific to a specific condition. I will point out that there are 2 conditions that one of 2 conditions have to exist regarding the ambulatory care facility, in addition to the fact that it is an ambulatory care facility, and I didn't bother to list those. But typically, it's because Group B doesn't in general require sprinklers. If you see an ambulatory care, you want to make sure that you look at these 2 specific requirements to see if sprinklers are actually required. So 102.2 talks about other laws. Other state laws, other federal laws. It also addresses municipal corporations' authority to make some modifications. So the first paragraph is that the Ohio Building Code, this code, is not deemed to nullify any provisions of state or federal law. So state and federal law will govern over the OBC. Municipal corporations, they do have the ability to make further and additional regulations relative to the building, provided they are not in conflict with 3781, 3791, or the rules of the Board of Building Standards. So they can add some or make modifications, but they can't be in conflict with the rules of the board. (102.3) talks about other rules. So 102.2 is other laws. This is other rules. Important to note here that the rules of the board shall supersede and govern over other rules. It also points out that other requirements that owners may be required to meet as set forth by their licensing agencies out of maybe the fire marshal's office, Department of Health, Job and Family Services, mental health and addiction services. There's a number of them. And that it reminds the owner and the designers that they should investigate for any additional licensing agency requirements and make sure that they're incorporated into the plans that they're getting approved if that stuff needs approval. So it would be a requirement for licensing, not necessarily a requirement from the building code. So the rules of the board supersede and govern other orders, standards, or rules from the listed group of, and I've just grabbed a sample here, but that's in that paragraph. There is one exception in that paragraph that under revised code 3743 fireworks, the state fire marshal can write rules, does write rules for fireworks, and their rules take precedent over the board's rules regarding 3743 and fireworks. So agency, again, reminder to the owner that they may, that the agency for licensing purposes may require the owner to exceed the code's requirements. And the owner must include any of those licensing requirements in their application, especially if those conditions require approval. Even though they exceed the code's requirements, they may still require approval to be completed. 1025 deals with referenced codes and standards. So we have laws, we have other agency rules, and now we have things that are referenced from within the Ohio Building Code that are part of the Ohio Building Code by reference. So if reference is made out of any one of the rules of the board to any federal provision, any industry consensus standard, or a technical publication, you want to go back and look at Chapter 35 of the Building Code for the specific date and title of that publication and the name and address of the promulgating agency to see what is the valid referenced provision, standard, or publication being used, and the work must comply with that reference there. Know that the building code is Chapter 35. The mechanical code is in the same thing is in the mechanical codes Chapter 15, and the plumbing codes Chapter 15 of those codes. Reminder that it's considered part of this code, meaning the Ohio Building Code, and to the prescribed extent. Most notably here would be something like NFPA 70, the National Electric Code. It is a referenced standard. It is listed in Chapter 35 of the Ohio Building Code, and it is considered part of this code to the prescribed extent. There's a lot of things in the National Electric Code that regulate scopes of work that are outside the scope of work of the Ohio Building Code. So first, the work has to be regulated under the Ohio Building Code. Then, to the extent of that reference standard is applied. And then finally, if differences do occur between the provisions of this code and the reference standards, this code, meaning the Ohio Building Code, shall apply. So there is a hierarchy there. 1027, one of my favorite sections in the building code. It's where I start a lot because so much of the time the questions that come across my desk are dealing with work on existing structures. Always a good place to start. Most notably, the first sentence here is that the provisions of Chapter 34 shall control the alteration, repair, addition, maintenance, and change of occupancy of any existing structure. So Before you apply any of the other technical provisions in chapters 2 through 34, or 30, I'm sorry, 2 through 33 of the Ohio Building Code, you need to go out to chapter 34 and see, based on the scope of work proposed, what requirements for new construction are required to be complied with. The next piece of this is that the occupancy of any structure currently existing on the date of adoption of this code shall be permitted to continue without change, provided there's no orders from the building official present, no evidence of fraud, and no serious safety or sanitation hazard. So, regardless of whether the building had complies with the current code, complied with the code that was in force at the time, got built without an approval. If it existed on the date of adoption of this code, so November 1, 2017 in this case, it will be permitted to continue without change. So the owner doesn't have to do anything, provided the building official hasn't issued an order and it's still pending and they haven't addressed it. For example, as they were building it, they got an order issued and they didn't clear that order. That order is still a valid order and the owner still needs to address it. There was no evidence of fraud, which sometimes, because they use the term fraud, sometimes it can be difficult to deal with that, because fraud is an intent and can be a little bit hard to prove. And this is probably the biggest one that gets building officials and building departments working on an existing building outside of an owner wants to make an alteration or repair, addition, maintenance, or a change of occupancy, that the owner has failed to maintain their building, or something has happened to the building where it has become a serious safety or sanitation hazard, then action must be taken on the building department side, and the owner has to respond to that order. So, there's a lot of existing buildings out there. Probably estimates north of 85% of the buildings that exist in the state of Ohio are probably or go through building departments for approvals are work on existing buildings. They have existed since buildings were being constructed in Ohio. Some of them. So some of them predate building code. Some of them obviously predate the current building code. But not all of them are going to have certificates of occupancy, and sometimes they're required to have a certificate of occupancy by outside entities, an insurance company or a licensing agency or something like that. This allows the owner to get such an approval for an existing building, and you have to jump out to section 111 to kind of go through that process. So they can get a certificate of occupancy for an existing building if one doesn't exist. And finally, there is just basically a definition included in this section that building constructed in accordance with the plans which have been approved prior to the effective date of this code are existing buildings. So if they have a plan approval from the 2011 Ohio Building Code, or they have a plan approval from some previous building code edition, it is by definition an existing building. And all this goes to a long list of arguments that have been made that basically buildings do have rights. One is that they are assumed to have complied with the code in force at the time, provided, again, going back to there's no orders of the building official pending, no evidence of fraud, and no serious safety or sanitation hazard. So if none of those things exist, that building is assumed to have complied with the code in force at the time, whether it has that certificate of occupancy or plan approval. Control for enforcement for existing buildings starts in Chapter 34. So anytime you get work on an existing building, you need to jump out and start out in Chapter 34 to find out what provisions for new construction, so those provisions in the technical sections, Chapters 2 through 33, are applicable to the proposed work in the existing structure. An existing building either has a certificate of occupancy or a plan approval per 102.7, or can get a certificate of occupancy for an existing building. These are sort of those conditions. Again, the certificate of occupancy may be issued to an existing building, and this is some of the language from 111.4. It has to be requested by the owner. The building department has the responsibility to investigate and inspect the building, and there has to be evidence that the use as requested it exists. So it has to be being used as they are requesting the certificate of occupancy for. Otherwise, it's a change of occupancy, and they would have to go to Chapter 34 for change of occupancy. Part of the investigation by the building department is there are no outstanding orders, and part of the inspection is that there's no serious hazard found. And then, of course, the 111.4, it is a certificate of occupancy for an existing building, not just a certificate of occupancy. This is important to note on that certificate of occupancy. 102.9, non-required work. I mentioned it earlier, but this is the section where you find it about non-required work, that if any construction is performed that is not required by the code, it shall be permitted. So the owner can do it, even though it's not required, the owner can do it. And it can be partial or complete, provided it is installed in accordance with requirements of this code to the extent of the installation. So if they are exceeding the requirements of this code, you know, the minimum sometimes the best example is usually fire suppression systems. The minimum might be an NFPA 13R, for example, and they want to install an NFPA 13 for whatever reason. They are permitted to install an NFPA 13, provided it's installed in accordance with the provisions in this code for an NFPA 13 system, which is going to have some slightly different requirements. And it's to the extent of the installation. Remember, it can be installed as a partial or a complete system. So if they want to put that in, they can. And the part that's over and above the minimum required can be partial, and to the extent of that partial installation has to comply with NFPA 13. Maybe the better example might be if a building didn't require a sprinkler system at all, and the owner wanted to put one in, they could put one in for a portion of that building, for example. And that portion would have to comply with the provisions for the level of fire protection service that they wanted to put in. Another important thing is section 102.10, work exempt from approval. This is different than the exceptions under 101.2. 101.2, remember, is the scope that's covered by the building code. This are exempt. Work exempt from approval is broken down. It's not required. However, all the work still must comply with the applicable provisions of the rules of the board. It's broken down into building, electrical, gas, mechanical, and plumbing, and there are 11 described, 6, 4, 7, 3 different described items under each one of those categories. So when you look at that, if they're doing just this work, they don't have to get approval. However, if they are doing it, they have to comply with the rules of the board. The most notable ones are things like in the electrical system. One of them is low voltage systems, less than 50 watts, don't have to get approval. However, if they're running wires in a plenum, the wires in that plenum have to be plenum rated wires because that's a requirement in the building code. They don't have to get approval, but they do have to put plenum rated wire in. If they penetrate a fire rated partition, they have to seal that penetration in accordance with the rules regarding that fire rated partition. They don't have to get approval, but they do have to install it in that way. Emergency repairs, 102.10.1, sometimes the repairs have to happen. They're time sensitive, they're weather sensitive. An owner is allowed to do that. If that repair work required approval, they need to follow up with the building department and get application for that work in within 24 hours of the repairs being done. Also 102.10.2, minor repairs. This goes back to that definition and why it's important for a minor repair. It is exempt from approval. So if an owner had a half a dozen shingles blow off their roof, they can replace those half a dozen shingles as minor repair and not have to get approval for that work. 102.11, building department jurisdictional limitations. You have limits about how far your authority goes. This is described here in 102.11, and it identifies that basically you shall enforce the rules of the board related to construction, arrangement, and erection of the building, except when it comes to fire, relating to fire protection. That's the we kind of talked about that in definitions. Health, relating to sanitary conditions. Sewer and drainage systems, basically dealing with building sewers and all laterals. Know that sewers are different from drains and understand that difference. Power generation is outside the scope. It's typically going to be with the utility company. Now, one thing about power generation that the building department should be aware of is that that utility that is doing the power generation, they may request that the building department review and inspect any work on their project, but that is at the request of the utility. The utility is not required to submit plans for the power generation, transmission and distribution structures. Then state projects. So again, remember, this is municipal, township, and county building departments. If the construction is on land owned by the state or the building owned by the state of Ohio, it automatically goes to the superintendent of the Division of Industrial Compliance. So here's our interlink process as diagram as we build the picture, kind of summarizing all of this stuff. An owner has a plan, they want to build a building. They have a design phase. They need to check with the building codes, any related fire codes, any local ordinances that they may have to comply with, any licensing agencies they may have to comply with. They prepare their plans, they get those plans submitted to the building department for review and approval. They cannot start any work without that review and approval. And that comes in the form of certificate of plan approval. That certificate of plan approval allows the owner to start their construction. They get their contractors, they start building, they start doing all that. The owner, as they're building, are required to contact the building department and have the inspector come out and inspect the work. There are certain required inspections that they're required to have. And if they complete all of those inspections satisfactorily, they will get a certificate of completion, certificate of occupancy. They cannot use or occupy their building until that certificate of occupancy is issued. That allows the owner to occupy their building. Now, one of the conditions of occupancy is that they must maintain that building in accordance with its approval. So the building code is going to cover this building approval process. So application of plan approval, certificate of plan approval, inspections, certificate of occupancy. That's the OBC. The OBC does allow for owners to do some preliminary work with the building department in terms of clearing up some ideas, get a preliminary plan review before the full one is made. Once that certificate of occupancy is issued, that's when the fire prevention process takes over and the fire code. Now, in certain jurisdictions, the fire chief may want to weigh in on the building approval process, particularly in the review of plans, and they have the right to do that. And we encourage building departments to coordinate that effort with the fire official. Now, the fire official does not control this process. They must complete their review and provide their information within the time frame of the building approval process. These various local agencies or licensing agencies, they may inspect and issue some type of certificate or license to the owner to conduct the operation that they want to conduct in there, and that's separate from the building code process, and we don't have much involvement there. Although what this license may do is require the owner to do something that is in this process. The owner then may want to alter, add, or change something about their building, that work, it's minor repair, may not require any approvals, but if it's more other than minor repair, they're going to have to do some kind of submission back to the building department. If they want to make an addition, they'll have to submit back to the building department. The fire official may go out there and in his annual inspections may find a problem. The owner may be able to fix it through minor repair, maintenance, or they may be required, because of the fire official's order, to come back to the building department to get approval for that maintenance work. Again, serious hazard would trigger the building official to come out, and the building official's order is likely going to require the owner to come back to the building department for approval. Also, the licensing agency may have annual inspections, and they may issue an order through the licensing that requires the owner to come back to the building department for approval to clear up whatever issue that is. That's how the process is interlinked and how it works. So that whole approval process, approvals are required. 3791.04 is where you find the requirement, and it is going to tie back to, you need to get approvals for buildings that are affected as described in 3781.06 and the rules of the board that are authorized through 3781.10. This is the legal framework. It is assuring public health and safety. These are the minimum requirements. It also indicates that no owner shall proceed with construction without approval. That approval is deemed a license, and that license grants the owner the right to build in accordance with that license. it does, in law, establish a couple of the time frames. One is that the plan approval must be performed in 30 days. And you will see this over and over again, kind of hammering into building departments that they have to get that plan approval process done in 30 days from the time they receive the application of plan approval. Because if they exceed that time, it is considered an adjudication order and the owner has the right to appeal any order that's issued. That this particular order would be the denying of the issuance of a license, or in other words, an approval, and it can be appealed. So approvals are required. 105.1 can't state it any more plainly. And there are actually two approvals in any building process. There is the approval to start, so the certificate of plan approval, and there is the approval to occupy, or the completion of the construction process and the permission for the owner to occupy their building. In this case, if an owner intends to do any of those activities for a building, they must first make application to the building official and obtain the required approval. In the building code, we have, this is considered the full approval. We don't actually have a word for it. We just call it the approval. If they get an approval, they are allowed to construct. That's their license. They are allowed to construct what is approved. There are other types of approvals, and we'll talk about them briefly. There's a non-conformance, a conditional, previous, phased, and annual approvals. So the non-conformance approval is issued when the documents that are submitted with that application do not conform with the requirements of the code. The building official actually can issue an approval provided that whatever is non-conforming is not going to be considered a serious hazard, and the owner has the responsibility to, it's actually further down, has a responsibility to submit revised construction documents within 30 days. If they don't submit those documents within 30 days, the building official issues an adjudication order revoking the plan approval. So what this does is it gives the owner an opportunity under the same application to get a non-conformance approval, provided it's not a serious hazard, but it does require the owner to resubmit revised construction documents showing compliance. And if they fail to do so in 30 days, that plan approval is revoked. This is a timing thing, and I don't know how often it's actually used. The next one is a conditional approval. This one, again, deals with documents that cannot be approved because they are not in compliance with the rules of the board. So he can't get approval. In this case, the owner can request the issuance of a conditional approval. And the building official issues it when that there's an objection and it involves conflicting interpretations of the code. So the owner believes he has a compliant building. The building official says, no, not a compliant condition because of this, this, and this. The owner says, no, I believe it is. I think I've met those conditions this way, and this way. The owner can request a conditional plan approval for those conflicting interpretations. Now, those conflicting interpretations have some conditions that they require only minor modifications to the construction, the design and the construction. It does go on to say that the building official cannot issue a conditional approval where the objection is to the application of a specific technical requirement or the correction would cause extensive changes in the building. So there has to be an evaluation made as to whether the request for a conditional plan approval is minor enough that it doesn't involve a specific technical requirement, and extensive changes aren't going to be required when that conflict is resolved, because then it goes further to say the conditional approval allows the owner to proceed to the point of the conflict, and that conflict will be identified as an adjudication order. The owner may appeal that adjudication order, and based on the results of the appeal, will determine whether a full approval can be issued, or they have to address the conflicting issue in a different way. Important to know that a conditional approval is not a phased approval, because previous approvals, I believe, are fairly self-explanatory. It's any previous approval, and that will apply to existing buildings, obviously, and it's important to know what they are, so to know what that building has been approved, lawfully approved for use as. Phased approvals, this one's probably the most used of the other kinds of approvals outside of a full approval. And basically it's basically issuing an approval for any portion of a building before all of the construction documents have been submitted to the building department. If the work that is submitted is compliant with applicable requirements of this code, the building official can issue a phased approval for that work. It goes on to say that the holder of that partial approval knows that they are proceeding at their own risk and without assurance that the approval for the entire structure will be granted. That because information is not known, construction documents haven't been submitted. When those documents get submitted, it may impact the previous work that was approved because of what's being proposed in that new location. Remember, the ambulatory care facility, if it's on a level other than an exit discharge, they got a phased approval for a foundation in a Group B building, and they're building up. Now they've proposed to put an ambulatory care on the second floor. They may be required to provide sprinkler systems on the first floor, and that may impact what was approved through a phased approval process. So an annual approval, this one is primarily used for more industrial applications, factory type applications, and that it basically is the building official issues an annual approval because that building owner has a lot of work going on where they're continually changing plumbing, mechanical, electrical systems. They're moving things around. They're adjusting to what's happening on their factory floor. The building official can issue an annual approval, so the building owner doesn't have to come back every time they're doing a little switch here or a little switch there. There are some conditions about issuing the annual approval. The owner has to keep records that the building owner has to employ individuals that hold the related board certifications regarding the work that's being done. So if they're doing electrical work, an employee who is responsible for the work being done at that company has to be an ESI or hold an ESI. If they're doing plumbing work, they have to be a certified plumbing inspector. So they have to hold the relative board certification for the work that's being done. The records that are kept need to be accessible to the board or to the building department. The building department should make regular audits of that work, of those records, and they must also, in those records, must also include the applicable construction documents for that work. Approvals have validity. They can be invalid. And again, this is reinforcing the fact that in the absence of fraud or serious hazard, any structure built in accordance with approved plans shall be conclusively presumed to comply with the rules of the board. So that again goes back to support those conditions that can invalidate an approval. It is considered to comply. An approval has an expiration date. It also can be extended. Know that an approval is invalid if they don't start work within 12 months of the approval. They can ask for one extension for that expiration. On the extension, if for whatever reason work is delayed for more than 6 months, the approval is invalid. And in this case, 2 extensions can be granted for 6 months each once work has started. So work has to start within 12 months. Once work starts, it can be suspended for 6 months, but no longer. And you can get 1 extension for a year on the expiration. You get 2 6-month extensions once work has begun. Otherwise, the approvals are invalid and the owner has to start that process over again. So, certificate of plan approval. This is what the building official is required to provide to the owner if they work that's being proposed is compliant. And it has certain requirements of what needs to be on the certificate of plan approval. And the board has provided an example of a certificate of plan approval with that information contained. You can find that information on the Board of Building Standards website under the Resources tab, and it will be in the Building Department resource packet. Remember I said there's 2 approvals. One is a certificate of plan approval. So before construction can begin, the owner needs to get one of these from the building official. Once the construction is concluded and all the inspections are satisfactory, the building officials shall issue a certificate of occupancy. And again, this is an example, and there's certain specific information that has to be on there. The Board of Building Standards on our webpage under the Resources tab in the Building Department resource packet has an example of a certificate of occupancy. So construction documents. The first thing here is this is basically telling the owner what the owner needs to provide for whatever proposed work they are doing. It is meant as kind of a laundry list, a checklist to communicate to the owner what they need to communicate to the building official and his plans examiner to demonstrate compliance. Sections, then and that would be in 106.1.1. So these construction documents are submitted for review. That's what 105 is saying. They are reviewed in compliance with the OBC. That's what 107 is saying. And then the building official shall issue a certificate of plan approval per section 105.2. Typical information that has to be submitted. There's several sections. These are the headings for each of those sections. It starts from an organization piece, goes to the more general, from the more general information to the more specific information, moves on to the various systems, and then any other additional information that's pertinent to the proposed work. One of the things that is noted in 106.1.1.1 is fire protection systems. Oftentimes an owner doesn't know what the fire protection system is going to be at the time of getting approval. If that is the case, the building official is directed in this section to issue a conditional approval for that fire protection system. So special inspections, the other thing that is required in the list provided by the owner or their design professional is the list of special inspections. So that's going to tie to Chapter 17 of the OBC. There's going to be potentially some special inspections that are required. That list has to be provided in the set of construction documents. There are 7 groups of special provisions. So we're going to specifically industrial units. Those are going to need board approval. Public swimming pools are going to need Ohio Department of Health approval. And this is going to be in addition to whatever requirements these things need from the building department out of the Ohio Building Code. Consumer fireworks are going to need state fire marshal preliminary approval. The FEMA elevation for floodplain work is going to have to be provided by the floodplain administrator. Fire protection system documents. Basically, this ties back to in jurisdictions where the fire official wants to participate in plan review. The building official needs to coordinate that effort with the fire official. For jails, prisons, and lockups, the Ohio Department of Rehabilitation and Corrections has to provide a preliminary approval. And hazardous materials, there are 2 paths here. One is if the hazardous materials are associated with building services, or if the hazardous materials are not associated with building services. So these are things to be aware of as a building department, that the owner is going to have to get approvals from some of these other agencies that should be provided to you in the set of construction documents so that you can do your work and review properly. 106.2 requires that the construction documents identify the person that is primarily responsible for their preparation. That if a registered design professional has prepared the documents, the seal that they put on is a requirement of their registration laws, and that we just require that evidence of responsibility. You can use the fact that the seal is there as having evidence of that responsibility. If technical analysis is required as part of the work, which happens with a lot of non-residential buildings or buildings regulated out of the OBC, that's kind of where that seal comes in, that the technical requirement or the technical analysis requires registered design professional involvement, and the seal is used for acknowledgement of that. We specifically identify where a seal is not required. It's not required in 1, 2, and 3 family dwellings, energy calculations, fire protection systems that are designed by a fire protection systems designer. They have a similar authority for the fire protection systems as they are a registered design professional for a fire protection system. replacement systems, equipment, and devices, and alterations not affecting health or safety in these areas of the building, means of egress, structural, mechanical, electrical, plumbing, or fire protection. Again, these things you'll notice are very similar to that list of things that deals with minor repairs. So there are some specific things that a seal or registered design professional is not required, even under the Ohio Building Code. If changes are made after approval is given, there are times when the owner has to amend the construction documents, and these are going to be for substantive changes. And they need to be submitted to the building official for review and approval prior to any of those changes being executed. Substantive changes are going to be determined by the building official, and they are typically going to be those things that require a different application or trigger additional requirements from the Ohio Building Code to as applicable. So 106.4, alternative materials, methods of construction. Remember, we want the building code to be helpful to the owners. So we don't want to limit them to a palette of things. If they have a material or a method of construction that is new or innovative or different or hasn't been done before, one way to help them get it approved is 106.4 for alternative materials and methods of construction, and basically it directs you to go to section 114, and Rob will be talking about that in part 2. You'll see specifically for prescribed equipment is 114.3.1, and not prescribed materials and equipment is 114.3.2. Alternative engineered design is the other way to deal with new, innovative, something different. That's 106.5, and as long as they comply with 106.5.1 to 106.5.3, they could do an alternative compliance. You need to look for a statement of conformity to the intent of the code, and you need to look that the work proposed is going to be equal or greater and in accordance with the manufacturer's instructions. The submittal shall have an indication on it that they are looking at a particular scope of work as an alternative engineered design, and the approval and the permanent record that the building department keeps shall indicate that 106.5 was used. So your records retention may allow you to get rid of the construction documents. However, the rules of the board require you to maintain a certain permanent record, which does not necessarily include the construction documents, but that permanent record shall include that some alternative engineered design was used. The technical data that is provided must be sufficient in substantiating going back to equal or greater and in accordance with the manufacturer's instructions, and prepared by a registered design professional. So plan approval process. Again, I go back to my little chart here. We're gonna be in this piece right here. And it's basically dealing with the plans examiner, who is going to be reporting his findings in the review process to the building official, so that the building official can issue whatever approval he can, so the owner can start the construction of his project. Again, we start with the revised code 3791.04, requires that approval before construction can begin. Documents must be prepared that show conformance, submitted to the building department, and must be approved. And who does the approval? Building officials do the approval. They have help from plans examiners, but you'll learn more about that in breakouts. So in that application process, The owner initiates the submission. They have the responsibility, if they want to build something, that they need to make application for plan approval to the building department. They are responsible to provide the information that describes the work proposed. It locates the proposed project. It identifies the uses and occupancies. They need to include construction documents and other information. They must sign their application and declare whether IUs listed in the label of projects or alternative engineered design is used. And finally, the building department must accept a submitted application for plan approval from the owner. They may not have adequate information on all of these things, but if they come to that counter and they want to make an application for a plan approval for work that they want, the building department must accept that work and the 30-day clock begins. Once again, this is a copy of an example of an application for non-residential plan approval. The board has created this form. You can find it once again on the Sources tab under the Building Department Resource Packet. And it has examples of all the required information and some of the other information that would be valuable to the building department and plans examiner and building official to know about the project so that they could complete a timely and accurate plan review. So there are time limitations on the application. I mentioned them once already. They come out of the revised code and they are echoed in 107.2.1 of the rules. That basically the approval is a license to build what is approved. The building department has 30 days to issue that approval, and in the failure to approve it within 30 days, it is considered a denial, and a denial, of course, it results in an adjudication order that the owner may appeal. Invalid applications. So remember, we talked about how that you have to accept the application. You can review the completed application, and you potentially could issue an adjudication order because of not enough information. After 6 months, automatically, if the owner hasn't responded to the adjudication order after 6 months, that application is considered invalid. That's what this is all about. So there is a time frame to invalidate the application for plan approval. And it requires accepting the application, issuing an order, 6 months passing without response from the owner. So the review of the plans, the building official can be done by the building official, master plans examiner, or an elective plans examiner. Obviously, the building official has to cause it to be examined. They may also carry the certification and can do the plans examination. Their job is to assure, as either the building official or the master plans examiner, to assure the coordination of review. Multiple parties may be reviewing those documents, and somebody at the building department has to assure the coordination of that review, that everybody's looking at, that all the appropriate things have been looked at by the appropriate people. If something is inadequate for review, you still must complete the entire review to the extent possible and report those findings and missing information to the building official so that he can make a determination, or the building official can make a determination for what approvals can be issued. Resubmitted, 107.4.2 talks about resubmitting information either that was inadequate or it ends up being amended. Once again, it's information that hasn't been reviewed before, so has to go through the process to get its review for approval. 107.4.3 talks about work that's sealed by a design professional. And 107.4.4 are fire protection system documents. And we talked a little bit about that when we were talking about the sealing of documents. So at 107.5, plans are reviewed. They are found to be in compliance. The plans examiner makes a recommendation to the building official. He communicates in his findings and he recommends a condition and the type of approval that could be issued. The building official reviews that recommendation and basically evaluates what he's found from the plans examiner and possibly the fire official. He makes the final determination of conformance, and if he determines conformance, he stamps and endorses the construction documents as approved, which, remember, that approval is a license to build what is on those construction documents. And that, along with that, he issues a certificate of plan approval with the list of required inspections, because it's going to be the owner's responsibility when the project gets to the point of needing a required inspection to notify the building department. But the building department provides that list. So the owner has the responsibility that they have to post this certificate of plan approval at the site until that final inspection is complete. And once again, the example of the certificate of plan approval. So let's say that there are items of non-compliance found in plan review. At this point, it is reported back to the owner that there's items of non-compliance, and the owner has two options to deal with those. One is he can revise the documents with the corrections and resubmit to the building department, or they can choose to not bring it into compliance, in which case the building official will issue an order and the building owner may appeal that order. And then it's up to the appeals board and the decisions made there what is needs to be done. So the building official, as a result of non-compliance, needs to add notes to the plan review recording the information about this issue of non-compliance, including the option chosen by the owner. Remember, we are responding to what the owner wants to do. Include what the code citation and the items of non-compliance and any actions needed to correct those items. This is all information that goes in an adjudication order. He does need to determine if it requires an order, and if usually if they decide to not bring it into compliance, it will generate an order and the owner can appeal. So once the approval is given, there's at least two construction document sets submitted with the application. One set is kept by the building official. The other set or sets are returned to the applicant. Of those sets, one set must be kept at the project site, including any manufacturer's instructions, and that all that information is made available for use by the building inspectors, because the building inspector's job is to review in accordance with the approved documents. So 108, the inspection process. Back to our chart here, we are going to be focused on our inspector. Remember, we have our certificate of plan approval with our list of required inspections. That's posted at the job site and the list of required inspections. So we're going to be dealing with the owner's responsibility to call in for an inspection. The inspector has to go out, and ultimately the goal for the owner and the building department is to get all satisfactory inspections so that the building official can issue a certificate of completion or occupancy, and the building can then move to the next step of occupying their building. So compliance. What are the concepts about inspections? Now, I know Rob is going to go into much greater detail, and I should have mentioned on plans examination, Debbie Oler is going to go into much greater detail about that plans examination process in the plans examiner breakout. Rob will go into greater detail on the inspections process in the inspectors breakout, and then also dealing with Chapter 1, Part 2 for orders and appeals. So the concepts that basically this is where it is confirmed that the actual construction matches the approved construction documents. Notice we say approved construction documents, very important. We do not say in compliance with the code. This is the plan review does compliance with the code. Inspections are matching the approved construction documents. We'll also talk a little bit about the types of inspections that must be done to ascertain that compliance. So these are the required inspections. They are so we will also briefly touch on what happens if the work is not built as described in the construction documents, because those provisions start in 108. They continue in 109 and 110, which Rob will cover. And then any stipulations, we'll talk about some of the stipulations on reference codes that need to be performed and the records of those tests that need to be made. So there are some things that need from the inspection process that need to be recorded and brought over as part of the permanent record. So the inspection process, it starts with the owner again at this point, and they are required to notify the building department when the work is ready for inspection, and they are to give access to and the means of making the inspection by the building inspector. So for them to get a satisfactory inspection, one, they have to tell the building department that they're ready. And two, they need to grant access to the building inspector and provide the means by which the building inspector can get to the work so he can adequately inspect it. Now, the building official, they have to provide that list of required inspections to the owner. That goes to the owner with the certificate of plan approval. The building official has to cause timely inspections to be made. So one of the key things here is that once an owner calls for an inspection, the building department and the building inspector has 4 working days to get out there and complete that inspection. If they fail to get out there and make that inspection within 4 working days, the owner is allowed to cover up that work and proceed with subsequent work to the point of the next required inspection. And then they're required to call for an inspection. Once again, the building department has 4 days to go look at that work. You can't go back on that subsequent inspection. You can't go back and inspect this work that was called for inspection and the building department failed to get out there within 4 working days. This inspection is conducted by a building inspector. Before they can go complete their inspection, they need to request and obtain entry. Now, remember, the owner has to grant access and a means of getting there, but they don't have to. If they don't, the building inspector can't make his inspection, so you can't get a satisfactory inspection, and that'll create other issues along the way. But the building inspector can't just walk on the site. They still need to request and obtain permission to enter the site to conduct that inspection. And their role is to compare the work completed with the approved construction documents, not with the code, not with what they think ought to happen. It is what is on those approved construction documents, and does that work that was completed, the actual work in place, does it match the approved construction document? That's the process in general. So required inspections, as listed in the code, it is a basic list, but it's not an all-inclusive list. This is the list without with just bullets, but these are the lists of required inspections. And one of the things you will note is that there is a tab down here for other, and it allows the building official through the plan review to identify other times when they feel that an inspection is reasonable and should be conducted, and they can include that in the list. And all of these that are applicable should be listed on the list of required inspections that go to the owner as part of their certificate of plan approval. Good example of one that might not be required. Let's say you're doing an alteration inside an existing building, you're not increasing the footprint, and you're not you may not require lot line markers to be verified and inspected as part of an alteration that is totally internal to a building. Same kind of thing with a footing and foundation. If no footings and foundations are going in, there's nothing to inspect. So you wouldn't necessarily require a footing and foundation inspection. So know that you can modify these required inspections when the work does not involve, the proposed work does not involve requirements about these categories. Right of entry is actually addressed in 108.4. That the building official or his designee, the building inspector, is authorized to enter the structure to inspect and perform their duties, provided that the building inspector shows the credentials to the occupant, and that entry is requested and obtained. So you are authorized to go in the building, provided you have credentials that identify you as a building inspector, the building official's designee, or the building official yourself, and entry is requested and obtained. It goes further to talk where permission has not been obtained or is denied, or the building official has probable cause to believe that there is a serious hazard in the building. The building official shall proceed. Section 109 is about orders, and whatever other recourses that the building official has to secure entry into the building. This usually is talking about an administrative order to gain entry, and that is a legal process by which an entity other than the owner is granting permission to the building official to enter that building legally. So there are the two cases about getting right of entry. It's an important thing. It's a legal thing. So summarizing it again in bullet points, you are being authorized to perform your duties. Your duties are to make a requested inspection. You may have some other duties required by the code, but primarily at this point, it's going to be required to make the requested inspections. Before you can enter, you need to present at a reasonable time, present your credentials, and request and obtain permission. So if you get a request 1 a.m. in the morning, unless it's specifically coordinated with the building owner, that is the time to do it, you have to be at reasonable time. Oftentimes that's office hours or when the job site is open. You have to have your credentials. You need to present them to identify you as an official, and you still need to request and obtain permission. And then, of course, reasons for getting an administrative order is that entry is not obtained as a result of denial or some probable cause that a serious hazard exists. So there is a range of results that can happen with inspections. Obviously, the first one, they can comply with the approved construction documents. That's the easy one. You get a little satisfactory check. The owner continues to the next required inspection. The inspector goes out, another satisfactory check. If the work does not comply with the approved construction documents, unsatisfactory check, and the building inspector has some responsibilities at that point. We'll go into those in a little bit. Then you could come into work that is not addressed or represented or is represented incorrectly on the approved construction documents. This one is a little bit tricky, but basically it would be something like there is no information, but the building code does require certain things to happen, and the building inspector knows that, and they haven't been done in what the building inspector believes is a code compliant way. Or if on the approved construction documents it is shown, but it is shown in a way that is potentially not compliant with the requirements in the Ohio Building Code, so represented incorrectly, the building inspector needs to know the building code so that they can address this situation, but they do not determine compliance with the building code. They determine whether or not the work done matches the approved construction documents. In this case, the work done may match the approved construction documents because it's not addressed, well, I should put it this way. The work done was not addressed, so there was no approval for that work done. Or that it's misrepresented, but the work matches the misrepresented information. It is incumbent on the building inspector to not say it's not code compliant, but he does have some responsibilities to report back to the building owner. We'll talk about that a little bit more. So the inspector, if they observe a potentially unsafe condition or serious hazard, they always have a responsibility to notify the building official in such cases. And usually we recommend that being done through some kind of verbal communication, because the building official because it's unsafe or serious hazard, people should probably be removed from the area, and the building official could direct the inspector to make that direction. So inspections and compliance, that's the easy one. If the work is in compliance, you communicate it to the owner, make a note in the inspection record and communicate that to the building official. Once all the inspections are complete and they are all satisfactory, the building official shall issue a certificate of occupancy. That's the easy one. So communicate, do the inspection, communicate to the on-site representative, make note in the on-site record. You probably want to make note in your own log too. Communicate the findings to the building official, and then once all of the required inspections are completed satisfactorily, the building official issues an approval. Inspections where you have a violation or an unsafe condition or a serious hazard, those are all covered in 108.6. If the building is constructed contrary to the approved documents, the building inspector directs you where you need to go, either comply with 108.6.1 or 108.7, which 108.7 is the building official looking at it for issuing an order. You note that it's an unsatisfactory inspection. You kind of once we get into 108.6.1, where the inspection shows a contrary condition, the board has prepared an owner compliance options matrix. Again, this can be found in the building department resource pack, and there is an option A, an option B, and an option C at the inspection process, and it talks about all of the steps to take based on how the owner wants to address the non-compliance. Basically what happens under 108.6.1, where something is contrary to the approved documents, you need to communicate the three options available to the owner. Option A is they can bring the item into compliance and ask for a re-inspection. They can revise the construction documents as option B and resubmit to the building department for approval, or they can request a determination or adjudication order from the building official. So this is, we don't want to change anything. We want to build it as we have. We want to leave it alone. The building official needs to determine whether it's compliant or not compliant and or issue an adjudication order to which the owner may appeal. You also need to communicate the findings of non-compliance and the decision from the owner, option A, option B, option C, to the building official. That's your job as an inspector on the inspection process. 108.6.2, this is the observation of violations not shown on the plans. This is where building inspectors need to know the code, but they don't inspect to the code. They inspect to the approved construction documents. But if they do happen to notice what they believe is a code violation that's either shown incorrectly or not adequately, that the inspector has to communicate to the building official so that the building official can make a determination. In that determination, the building official has a couple of choices. One, either let the work stand, or if it is significant enough, he may want to communicate to the owner a notice of recommended change. Remember, an approval has been issued. The owner has a license to build what's on the approved documents. If something is a code violation, it can be a notice of it would fall into a notice of recommended change to the owner if they chose option C, unless in fact it's a serious hazard, in which case that needs to be corrected, which is 108.6.3. So if the inspector observes an unsafe or serious hazard, he shall communicate the conditions to the owner, report the findings immediately to the building official, so that the building official can make a determination whether it is or is not a serious hazard. And if it is a serious hazard, he must issue an adjudication order, and then you follow Section 109. So 108.7, this is in all those communications of work contrary, the building official's determination of non-compliance. This is what the building official is required to do as part of that inspection process. They need to evaluate what the inspector is telling them. They need to render a final determination, and they need to determine whether an adjudication order is necessary. The building official will make that determination within 4 days of the inspector's reports. So you have a time frame, and there's potential of requiring an adjudication order being issued, or a notice of recommended change, or it's not of such significance that anything needs to be done. The owner continues to proceed with his construction. The last section I'm going to cover is certificate of occupancy and completion. Remember, this is the last step on the building approval process. This says this is granting the owner the right to occupy and use their building. It starts off that no building shall be used until the building official issues an approval. That approval comes in the form of a certificate of completion or certificate of occupancy. The certificate of occupancy is dealing with any space that has a change of occupancy, it's new space, it's a new building, where the risks have increased and you need a certificate of occupancy to occupy the building. On that certificate, one, it will have that it's in compliance and has any stated conditions of how the building can be used. This is information really for the permanent record to help down the road what has been approved in the past. And as you start working on these and filling these out, you'll know that approvals come with some stipulations, and sometimes those stipulations need to be reflected in the certificate of occupancy. Note that also in this section that the building and all building service equipment shall be maintained in accordance with the approval. That's to help keep a valid certificate of occupancy. The next paragraph is all about that the building official, he must issue a certificate of occupancy provided there are not violations of the rules of the board or orders of the building official pending. So this goes back to, if all the required inspections are satisfactory, the building official must issue a certificate of occupancy. And then they are also required to provide a copy of the certificate to the local fire official, because the local fire official has some annual responsibilities to perform with that building based on the certificate of occupancy from the building official. So new buildings and structures get a certificate of occupancy, additions, changes of occupancy, partial occupancy, time limited occupancies, temporary structures. These are all examples of when a certificate of occupancy is used or needed. Most of them are self-explanatory. Perhaps the one that is needs a little bit of communication is the time limited occupancy. And to that extent, the Board of Building Standards has provided a an explanation of the use of a time-limited certificate of occupancy. Once again, it's in the Building Department resource packet. The other is a certificate of completion. That's at 111.1.2. This is specifically for alterations and repairs. You'll use a certificate of completion. These are the kinds of things where the building owner or occupants may want to continue to use the building while the work is going on. The work that's going on doesn't really affect the occupancy of the building other than the inconvenience that the work is happening. And it made no sense to have a certificate of occupancy required, so we've added a certificate of completion for these particular projects. So certificate, the issuance of the certificate, basically there's certain information that must be provided on the certificate. And basically it states the purpose for which the building or structure may be used. It may have multiple different uses. And there are 12 specific things that must be contained in the certificate of occupancy. So
Jay,
this is the list of 12. Yes, I see that I am at my time. Maybe a little past. We're
going to need to call it cuts at this point. Jay, thank you so much for the presentation. The next class will be beginning in 5 minutes, Chapter 1, Part 2 with Rob Johnson. Thank you all for your time and attention. And please come to office hours at 12:30 or at 4:30 today to ask any other questions you have. The questions that have been entered into the chat will be answered by email to all class participants. Thanks very much. Thank you, Jay. Sorry to interrupt you.
No, that's fine. I was 2 slides from the end. We're good.
Good. All right. Thank you.
Yep. Bye.
Take care, everybody.